Thanks to all the panelists for sharing with the audience your wealth of knowledge. I want to build on Akira's comments made just right now. Indeed, the landscape of data privacy internationally is changing by the day. And in order to keep up with all these changes, it's really important for any company to get to Privacy Rules Alliance in order to receive a specific jurisdictional advice from our advisors, from our members in all these countries who are actually interconnected among each other, and therefore can advise not only for what is specifically related to one jurisdiction, but actually at global level. So this is definitely the advantage that our alliance can offer, which is definitely a competitive advantage for all of you in the audience. Thank you very much again. I will now pass the floor to Joe Dehner, who will be moderating the next panel, and who is also the chairman of Privacy Rules, luckily for us. So he will be driving us into the concepts related to data breaches from the prevention and response side. Again, thank you very much for the panelists of the first session, who will be still here with us, ready to answer to questions in a question time after this upcoming session. Thank you.
Well, thank you, Andre, and thank you, Akira, arigato. And for our listeners, the background here is the way data works. You don't see borders there, do you? Data's like that. And we're going to focus on breach now. And when there's a breach of data, it goes all over the world. It doesn't really care about borders. But regulators do, and consumers do, and businesses do. So we're going to look at data breach in two pieces, give you a quick tour around the world using 5 real experts on this subject. I'm going to introduce them very briefly so we get right into the merits of the discussion about how do you prevent a breach, and then how do you deal with, or how do you respond to a breach. So very briefly, we have with us Kohei Kurihara. Kohei is co-founder of the Privacy by Design Lab of Japan, and I'll turn to him as our first speaker in just a minute. Kevin Warburton is with us from Hong Kong at the great firm there of Tanner DeWitt. Thank you for joining us, Kevin. Grace Shaw is part of Macmillan. Macmillan is a law firm throughout Canada, which is a number of time zones, geographically as large as the United States. Yeah. Ken Morris is with us. Now, Ken's an attorney, but he's really here as one of the top cybersecurity experts. He deals at very high levels around the world on how do you really deal with data that is so global and so apt to escape and have problems. And Ken will give us some very interesting information. He joins us from Minnesota. Thank you for joining, Ken. And then there's Eric Cook, colleague of mine at Frost Brown Todd, and our law firm is in 14 cities of 9 of the United States and deals very nationally. We're all part of Privacy Rules, which tries to solve problems around the globe for businesses and people. So we're going to talk about data breach. Now, data breach is something that is very costly if it happens. There are estimates, the average cost of a data breach can be up to $3 million, depending on the size, and that's an average. You get the enormous data breaches suffered by Equifax and Target and other large companies in the United States. These involve tens of millions of people and their individual data, and were far more expensive than that. And even for smaller companies, the cost is great. And beyond the financial cost, the reputational cost is very significant. If your clients and your consumers and your business allies can't count on you to keep personal data private, they may not want to do business with you. And the reputational risk can really bankrupt a company. So it's very significant what we're talking about. Well, I want to start with Kohei. And Kohei, you're a very special guest from the Privacy by Design Lab. In your experience, what do companies really need to do to prepare so they don't have a data breach?
So yeah, first of all, thank you for the invited. Great to be honored to participate in this conference. So From my perspective, data breach is the increase in the numbers since our business is going to the online. In total, the 2020, the Japanese over 1,000 instances up to the 65 cases at this moment. What we have to do is to develop our preventive cultures regarding the data privacy internal operations, because data breach is no longer the rare cases, it happens everywhere. So it's a times we change our mind, not just the security strengthen, we have to prepare for the times to deal with the internal management. For example, when Japanese big instance recently happens, over 6 million data has been breached through the event platforms. The problem is a lot of the stakeholders is using these websites, then they have to apologize these for all the users through this platform. So this is the kind of the communication issues for the multi-stakeholdings. In case of the data breach, data controllers need to communicate with them to report what happened actually, and they need to update in each status. Whose data has been like the stories, what could be the data impact, data breach impact, how those stakeholders needs to be prevented. So those are communication issues. So my idea is that we need to prepare to educate internal management. They need to make the trainings of unintentional consequences. So this is my idea. Also, the lot of enterprise needs to be prepared well for the educational internal management.
Thank you, Kohei. Let's move to Hong Kong now. And Kevin, let me ask you, tell us a little bit, what is a data breach to begin with? And then how can a company really best plan to try to prevent them?
It's a very good question, Joe, and one that isn't necessarily always easily answered. So I'm glad you've asked it. But before I answer it, just very quickly, delighted to be virtually here in Tokyo today, representing Tanner DeWitt here in Hong Kong. Tokyo is somewhere, here in Hong Kong, we're only down the road from Tokyo, and we look forward to returning there very soon. So yeah, what actually is a data breach? Well, I think a data breach is something that affects we have an incident which affects either the confidentiality, the integrity, or the availability of some data. And that gives rise to a real risk of some sort of loss or damage. So I think it's important then to remember what a data breach isn't. So it might, for example, not be a case where we have a potential incident and our systems, and we'll talk about these systems, when our systems kick in and act to prevent any loss arising, or there might be something that happens and the systems kick in and it maybe goes beyond our systems and we can learn from it and adapt our systems. But I think when we're looking at a data breach, we're looking at something that affects the confidentiality, integrity, and availability of their data. And I think it's also important to remember that data breaches, yes, they can be deliberate, so in the form of some sort of electronic attack or electronic incident, but we also still need to remember those kind of slightly more old style, data breaches, which can come down to pure accident or human error. So, think about the lost laptop or the lost cell phone, something like that. And how can we prepare? How can we prepare for a data breach? Obviously, we never want one to occur, but I think Kohei's point about engagement within the business and proper training is absolutely one of the central aspects of this. And we need a proper breach response mechanism, and I think that has to be endorsed from the very top. Because that kind of thing is going to be expected and often required by not only by regulators but also by our customers and our data subjects. And I think it's important that response mechanism, when we're preparing and training, that has to be consistent across all of our business. So one of the clients that I've worked with, a big multinational, they obviously, we've talked a bit about the different regimes already. We may have different thresholds for notifying a data breach. So I think it's important that we adopt a higher standard as we possibly can, so that internally within the business we can assess the impact of any data breach and what we might need to do. So I think that proper preparation is key.
Very, very helpful information. And of course, people are estimated to be 85% of the problem. They get phished, or they lose their laptop, or But it's not just that. And let me turn to Ken Morris now, because Ken, technology has a lot to do with this, doesn't it? Now, you're a specialist. You deal with data in flight. It may be one thing if I have my personal data locked in my safe, but once I let it go, that's really where we see problems. And would you talk to us, Ken, about different countries have different rules on what you have to do, what best practices are, what is a minimum that you must do. But talk to us a little bit about how can a company certify and demonstrate to regulators and to its ecology, its consumers, and so on, that it is protecting data in the life cycle of data.
Joe, thank you. Thank you, Andrea, again for the opportunity to chat with the group here. In an interesting turn of events, technology typically is running years ahead of regulators. In the instance of protecting data, the regulators have the upper hand at the moment. And when we think about data in transit, when it's outside of network boundaries, current best practices, people will use something called public key encryption. And by the way, encryption, the math itself is not the problem. Encryption is fine. But there is no way to know, given current best practices, when data leaves your network boundary and it is moving over the optical cables, headed to another jurisdiction somewhere around the world, you cannot track it. You don't have a way to know what's happening to that data. And so one of the challenges is, how can you certify the integrity? And I appreciate what Kevin just said about confidentiality, integrity, and you think about availability and use of the data. You have no way to know that under current security sort of best practices. And so one of the things that we would like the folks to think about long term is having a structure in place that allows you, and that technology is available today, to assure that, in fact, if that data has been impacted in transit, you know that. You have automatic breach detection or threat detection on that particular data. It is logged. It is something you can send to your security operations center or to your SIM. So you have essentially 24/7 view of what's happening to your data. As you mentioned, Joe, pretty easy to keep track of it once it's in-house, but extraordinarily difficult once it has left. And so looking at these fundamental principles at the end of the day, I think will be really helpful for organizations as they look for technology that allows them to actually track it, but do so without having to decrypt it in flight, because that adds another threat surface as well.
Well said. And there's this debate. What is the problem? Is it compliance? And certainly Kohei has talked about that, but it's also code. It's a combination of the technology and getting our workforces up to speed on protecting things. Well, let's move to Canada. And Grace, I can see you're with me in outer space, looking down at the world, and a big part of that is Canada. So talk to us a little bit about the other end. I mean, what are the problems and the penalties, that face businesses as they look at this?
Yes, thanks, Joe. And good evening, everyone from Vancouver, Canada. Very happy to be here joining you on behalf of Macmillan. So this is an interesting question, as it highlights some of the significant changes that are coming to Canadian privacy legislation quite quickly on the horizon. So as some of you may be aware, the Canadian privacy framework is quite complex. There are a number of statutory reporting obligations under the private sector, the public sector, health sector legislations all across the country. And in addition to that, some regulatory bodies have set reporting guidelines for specific industries, such as financial institutions. So there's a lot going on in the Canadian privacy landscape. But the landscape for breach reporting is only going to get more complicated as more jurisdictions in Canada are seeking to reform their laws to address the significant increase in privacy and cybersecurity incidents that we've seen over the past 5 to 10 years. So for today's purposes, I'm just going to focus on the private sector, and I'll start with the current regimes. So currently there are only 2 private sector privacy statutes that contain mandatory breach reporting obligations. And that's the Federal Personal Information Protection and Electronic Documents Act, or PIPEDA, as it's commonly referred, and the Alberta Personal Information Protection Act. So these breach reporting regimes under both statutes are quite similar. And under both statutes, the maximum fine for failing to report a breach in accordance with the rules is $100,000. And while that is relatively modest, I know, compared to a lot of other jurisdictions in the world, now I'm on to the upcoming changes. So in June of 2020, Quebec announced a total overhaul of its privacy legislations, which include mandatory breach reporting and updated penalties for contravention. So a far cry from the current maximum penalty of $10,000 under the Quebec privacy legislation for any offense under the Act. Organizations would now face the risk of being fined from $15,000 to $25 million, or 4% of their worldwide turnover for the preceding fiscal year. The last amount is greater. And then just last month, the federal government of Canada announced its own overhaul of PIPEDA, which will include increased enforcement. So the breach reporting requirements are probably going to stay quite similar because they were only actually added to PIPEDA in November of 2018. However, the changes proposed would include the potential for penalties of up to 5% of global revenue or $25 million, again, whichever is higher for certain offenses. So as a privacy lawyer in British Columbia, I'm very interested to see where my province is going to go regarding breach reporting and overhauls to the legislation generally. But suffice it to say that compared to the penalties currently in place, the upcoming changes put compliance with Canadian breach reporting into a whole new light. And that, coupled with the ever increasing risk of data breaches, which is never quite zero, certainly makes this issue front of mind for most of the businesses that I'm working with. Thank you.
Thank you, Grace. And you've introduced it's not just the federal legislation, is it? We have provincial legislation in Canada, and now we're going to turn to the United States, where we call them states, not provinces, but we'll turn to Eric Cook. And Eric, thank you for joining us. Talk to us some about the typical, the most common causes of a data breach from the U.S. perspective.
Yes, thank you, Joe, and I'm super happy to be here and be speaking to you all this morning for me. I want to begin by saying, once again, my name is Eric Cook. I'm located in the States, Cincinnati, Ohio to be exact, practicing at Frost Brown Todd doing data privacy, specifically in children's privacy, healthcare privacy, and the California Consumer Privacy Act are kind of my focus. Is all of these acts have requirements, data security requirements that everybody particularly needs to pay more attention to. Turning to that question, Joe, and I think what you'll see common among all of the speakers as well as myself that I'll kind of push on is that we need to identify the threat. We need to have policies in place. And as I've kind of heard from Kohei and Kevin as well, that training is a must. One of the big threats that we are seeing most in the US and that continues to move forward is phishing. And this is simply just sending an email as a bad actor to an employee and either accessing their credentials or in some way getting them to give you additional information. I thought the best example would just to speak about my experience with working with a client who simply just had their email credentials taken. They were basically having those emails diverted to a junk mailbox. They were not receiving them. And as a result, the bad actor was receiving these emails directly and asking for payment and getting it issued. And it was just that simple. And so just in the US need to identify that threat, which I think is kind of the precedent that leads to a lot of the other ways that things are occurring. But then the act of actually having a policy in place here in the US needing to walk through that process of making sure employees are aware of that. And then finally, you can't just have that policy in place and that process in place. You have to be training actively the employees with regard to that. So identify the risk, have some policies in place, make sure you're training your employees on those policies so that they're aware of these common attacks.
Thank you, Eric. And, this is the prevention side, and with complicated rules on that and what best practices are and how to deal with this. But let's turn now to the flip side. What do you do if there's a data breach in a company or in government or whatever the source may be? And nonprofits can suffer these, certainly. So that's what we're going to turn to as we finish off this part of the program. And again, I'm going to start with Kohei, speaking about companies. How can a company, what does a company do in responding to a data breach? How can a company make trusted relationships with its consumers?
Yeah, thank you, Joe. As you mentioned, that's the trust is based on the relationship with the customers. As I mentioned the last time, the compliance is the trading is the internal management. It's just in a defense. But the trust making is just the offensive actions from the enterprise side, such as the public relations, public communication with the customers, especially any instance in the cars, the company is delayed to announce the internal operations or risk assessment, risk management. The problem is if the delays, the consumer is getting the worry about your trustees. So that's a lot of the company needs to prepare or ordinarily promoted your accountability operations. So this is the one way to build up the trust with the customers. Besides, we need to be a clear, transparent operations in terms of data using, such as you set the specific purpose, then the limited the data uses, the data collections. Otherwise, you will lose, so you will be distrusted from the customers. For some cases, such as the employment engagement tools, sometimes these tools is being used unintentionally to collecting the employees' data. But from the employee side, they are worried about why this data could be collected and used for any purposes, such as the scoring system. We talked about these topics with a lot of enterprises, internal management, just using the software services, the collecting, the tracking the operation, especially in the remote works. So the employees are worried about why this company is using the services. So this is the one cases. You have to explain to all the stakeholders why you need this data. Then also you need to promote and make a clear announcement why you have to provide the data for us. So this is the very big steps to build the trust with the customers.
Well said, Kohei. Let me turn to Grace this time. We're talking about gaining the trust and keeping the trust of customers, but that's not just within Canada, is it? I mean, Canadian companies, I'm sure, Vancouver, a major global hub. You have people from all over the world coming to Vancouver, living in Vancouver. So what are the benefits to an international approach to getting ready in case there's a data breach?
Thanks, Joe. And I think my response to this question is kind of a summary of all the great points that we've been hearing throughout this panel. But there definitely are benefits, certainly from an optics perspective, to an international approach to data breach reporting. A robust privacy program is increasingly becoming the norm for companies and certainly an expectation of its customers, where their personal information is being handled, whether it's in a transaction or whether it's being collected in order to provide services. So certainly being able to advertise and demonstrate international compliance is a benefit for marketing and for customer trust, as we just heard about. There also are, of course, benefits from an internal risk management perspective. avoiding, just being on the right side of the law, avoiding scrutiny, fines, negative press, the publishing of publicly available reports of findings from regulators. So really, the benefits are from all angles, and while there are many, what I find is that an international approach continues to have many challenges for companies. Communication, timing, focus, different reporting thresholds, different contents for notices. And in today's e-commerce world, you know, business often operate outside of their home jurisdiction. It's actually quite rare to deal with a company that solely operates within British Columbia or Quebec or Alberta. So the reality is that an international approach to data breach reporting is just becoming more and more essential. And while we're seeing signs of harmony or, you know, borrowing of concepts from, you know, the GDPR into Canada, certainly between international breach reporting regimes and standards, you know, we're always going to be dealing with different legislative frameworks and regulators, and that's just something that's not going to change. And so I think, as we've highlighted today, the best approach to data breach responses involves having a plan within each jurisdiction that a company operates within ahead of time before the inevitable happens. Thank you.
Good advice. Ken, let me turn to you again. You know, what are the principles that a business ought to think about deploying to protect itself and its ecology against cross-border data transfers that can go wrong?
Well, the technology community has embraced a concept of zero trust. It's a little bit of cognitive dissonance, but it goes directly to this idea of you check and you verify everyone, everything, every device. Well, in order to do that, we do have to have a bit of an overhaul of our current data security framework. And so there's three core principles that are wrapped around one objective. And the objective is to assure that data is only available and can be used by authorized and approved parties. That includes data processors, data controllers, and the like. And so, one, there has to be continuous monitoring of your data wherever it is throughout its entire life cycle. Unfortunately, today, we don't do that for data in transit, which would obviously include cross-border data transfers. Second is have an audit trail for all activity on that data, regardless of where it is, which also includes you need to know what's happening to your data while it's moving from point to point outside your network. Three is to have a form of immediate breach detection. Again, today, not really possible with current best practices, but we hold to the notion that there are technologies out there that will allow you, even without encrypting, decrypting the data, which is another threat surface, to actually check on the health of your data while it's moving in those few microseconds or milliseconds, depending on where you are on the planet, to know what is occurring with your data, who has access to it, what devices have attempted to encrypt and or decrypt. But those, I believe, are core to organizations as we go forward. And finally, there's this conundrum that continues to be raised around nation states' need to have sort of law enforcement access to data. And one of the problems has been the ability for nation states to do essentially broad sweeps of data. And if they're after Sue Jones, unfortunately, they get everybody else, including Sue Jones, in that data pool. Well, there are, again, technologies available that allow you to have, with a valid warrant, of course, the ability to target just the one individual. Now, this only works if you have the ability to audit all activity associated with that particular data. And so one of the challenges, again, infrastructure needs to be improved a bit globally in order to assure this is happening, to provide for what Kohei talked about and Grace talked about as well in terms of trust. People will not have trust if they know you cannot audit, if you don't know what's happening to the data. So one of the proposals that we have, and we continue to speak about this globally, is assure that you always know where your data is. It's the old saying, it's 3 a.m. Well, not quite, but do you know where your data are?
Very good advice. I'm going to turn to you, Kevin, because this is a timing problem. Some countries you must notify at least the authorities and often everyone affected within 72 hours. How's that? Just sure, we'll just roll it out. And yet, a lot of the data breaches is it a data breach? It's not that clear. Someone lost a computer. Well, is that a data breach? Someone got phished. Well, how bad was it? So it's not always easy, is it? So talk to us a little bit about some concrete tips to businesses in the audience. What should they do if they suspect there may be a data breach?
Yeah, I'm glad you've raised this, Joe. And I think the point that you and Grace had mentioned about notifiable data breaches is one of the really key aspects here, because not every breach is notifiable. So we need to, the companies need to be need to get to a point where they can make a decision about whether or not to notify and who they need to notify, be that regulators or affected data subjects or contractual counterparties. So, what do we need to do? Because one of the key points to bear in mind is that the person discovering the data breach or what may potentially be a data breach is not necessarily the person that's going to make the decision or carry out the notification. So this comes back to us needing to have our breach response mechanism in place. And so once we discover a potential data breach, the first thing that we need to do is we need to activate that breach response mechanism. So the proper training, that means that we need to understand who to notify and how to notify internally within the organization. Then once that notification has made its way through the activated process, step 2, we need to assess what's happened. We need to understand what's happened. And this comes back to Ken's point about us monitoring what's going on with our data and having a proper audit trail and a proper record. Because if we have that, then it becomes much easier for us to assess the situation. So we need to understand what data has been affected, how long the data breach has been occurring for. Many of these data breaches go on for weeks and weeks before they're discovered. So we need to understand what data subjects are affected. So this assessment, coupled with the records that we've been keeping, hopefully then puts us in a position to understand the nature and extent of what's happened. Then thirdly, we need to contain the breach. What can we do to stop and prevent any further damage? Can we switch off any systems? Can we restrict access? Can we reroute access? Obviously, very technical aspects which are far beyond my levels of expertise. And then once we've paused and once we've got everything contained and under control, then we need to carry out the last 2 steps. Step 4, we need to investigate what's gone on. How can we improve our systems in the future? How can we potentially work with regulators to understand what has happened? And step 5, running in parallel, we need to mitigate the loss here. So we need to work with our stakeholders. And throughout that process, we need all sorts of different people involved. We need engaged people within the business. We need very senior people engaged, and we need decision makers in there as well. And we need counsel, internal, external, and we need experts from some of the fields that we've got represented here today. So I think they're the key steps. We need to activate our response mechanism. We need to assess what's happened. We need to contain the breach, and then we need to investigate and mitigate the outcomes.
Well said. And Eric, let me turn to you, and particularly perhaps what tips might you have for the Japanese companies in the audience, or any global company in the audience that does business in the United States, and there are many of those. So two questions to offer you. What regulations might affect Japanese companies that collect, disclose, store, and delete personal data to and with the United States? And then what laws and regulations apply to those companies about the nature of the compliance program that they should put in place? What are your thoughts, please?
Thanks for that question, Joe. In many ways, the answer is almost the same for both of these questions. With many Japanese companies and any other company pretty much that intends to operate in the U.S. has to always keep in consideration is the fact that we are complicated in the sense that we have the federal, state, and local laws. Now let me be specific about that. There is technically no federal law or regulation regarding directly data security. However, the Federal Trade Commission has continued to be kind of the enforcement arm related to data security. And they've done that under this premise that you basically do what you're telling people you're saying you're going to do in your policies, which is pretty simple. But where it gets complicated is all 50 states have different data breach notification laws, in which case it can get really complicated. And in many instances, these data breach notification laws require certain data security requirements. So at the federal level, many Japanese companies just to think about just generally what notices do you have out there and are you following them? At the data breach state by state notification level, they're going to need to be aware of what states they're operating in, what states you are operating in, and what you're doing. But then probably most important is California's Consumer Privacy Act, the Massachusetts Data Security Regulation, and New York Shield Law. Specifically, Massachusetts, I'll be brief, requires a written information security program, and it's a requirement. What's unique about all three of these states is they're kind of extraterritorial regulation. As long as you're collecting information from a California citizen, New York citizen, or Massachusetts citizen, you are now brought into that regulation, whether or not you have operations in that actual state. But each one operates in the US under this premise of having reasonable data security measures in place. And that's where you need to call counsel to figure out what reasonable data security means here in the States. So making sure that you're looking at that federal, state, and local potential operations and laws in place.
Thank you, Eric. Let me go back to you, Kohei. We're so happy you could join us today. Here's sort of a final question before we wrap up this piece, and then we'll open to questions and answers. So as the audience has them, please use the chat box or the Q&A box to submit them. Kohei, here's my final question to you. What does a company need to do as a first step to achieve a proper balance on the use of data, the transfer of data, and protection of data? What would you say the first steps are for a company?
Sure. From our experience and our practice, please start with the small teams who's associated with the privacies, because the privacy will be the fundamental, but this is the very challenging issues. So our advice and our recommendation to start from the people who is in a similar interest to focusing on the privacy, customer relationship to be gathered with a diversified team, such as the 2 or 3 team members, started from the just study sessions, the small workshops, anything, to engage in each other's. And the next step is to try to make an official teams, internal companies, because the privacy is very ambiguous for all of them in the companies. So we first put the common languages. What is the privacies? So this is the first steps. The team is a very great approach for the future management. Then those teams is try to be working together with internal projects to penetrate the privacy cultures into the new business. So this is my practical advices for all the companies to start. And they try to use the external expertise, such as the lawyers, such as the compliance professionals, such as our kind of the non-profit associations, to give them some external insight. So this is the kind of the initial steps to make and implemented the privacy protected cultures for the management process.
Well said, Kohei, and we'll turn to the questions and answers of the audience. I'll turn it back to Andrea for a minute, but just a very brief wrap up. Companies often don't understand the data they have. Companies allow their employees to go into Facebook, and suddenly there's all sorts of information within the company database. companies end up with the credit card numbers of employees and what hotels they stayed at when they were traveling. All sorts of information companies don't think of as their core activity. And so privacy is very much at stake in all we have talked about. We haven't touched on cyber risk insurance, which is one thing a company can do. That doesn't solve a problem. That just may help pay some of the legal costs and the defense costs and maybe some of the damages if some consumers sue for it. So that's a piece of it too, but it's quite clear this must be done on a global basis with very different laws, not only by countries, but by states and provinces, and even cities are into the act to some extent. And that's why Privacy Rules is hosting what we're doing today, and that's why we're launching in the year 2021 a mechanism to deal both with the prevention and the response side. So I'll turn it back to Andrea for the last half hour of our program.
Joe, thank you very much. Absolutely well said. And complementary to the data breach prevention and response mechanism that you just mentioned, Joe, we are also launching an e-learning platform. A relevant part of it will be dedicated to data breach prevention, in fact. You underlined already that a large part of the risk for companies is in fact related to behavior of employees at any level in the ladder within the company. So we want to address specifically this issue and help them preventing behaviors that indeed put the data of the company at risk. I want to feel somehow in Japan today, so I will say arigato to all the panelists for this incredible wealth of knowledge that you have shared in a very concise manner. If I can summarize with just 2 words each of the sessions, I would say complexity for what concerns the first session. We have learned actually that the one of data protection is a very complex word. And I will use also the word of grace, plan. You need to plan in order to prevent a breach. When a breach occurs, in many occasions it's already too late and you're going to face incredible fines. And as Joe mentioned also, a damage to the reputation of your company that might be irreparable or almost irreparable. So I would like to pass the word now to Akira as our virtual host to trigger a debate among our panelists, all of them, the ones of the first session and the one of the second session. A special arigato actually to Kohei as our special guest, as a known Privacy Rules member. We already had him before in another occasion, and we hope to have him again in the future. And then I will submit the questions that already came through the Q&A. And if anyone in the audience wants to put some more, this is the time. So Akira, thank you. The word goes to you.
Thank you very much. So I read one question that coming to, I believe, the first session panelist. So I read the question. Considering the rapid changes, how can we close the gap between the compliance legal experts and the technology teams responsible implementing the relevant controls, mostly in relation to data protection? Can you share any examples of best practices related to pragmatic approaches on cross-border data exchange? Maybe I should start from to answer this question. So in many of the cases, when I feel the gap between the legal team and the technology side, like the IT back office, I ask the client to team up members comprising personnel from both of the department. So one from legal at least, and one from IT or tech side at least. And then they discuss together with me on the aspects on how to create the compliance system which is compliant with the cross-border transfer restriction. Why the IT teams are necessary for such discussion is that this is a security measure perspectives. So in most of the jurisdictions, it is required that if you transfer the data to a third country, under the contractual arrangement, you have to install the sufficient security control measures from a technological side, that you need to install a sufficient technological security control measures. Whether the measure is sufficient from an IT perspectives, we need the assistance from an IT personnel who knows the IT system of the company, and the legal side can draft the contract or negotiate what should be written in the contract, but they don't know how the data is actually handled in their IT systems on a global basis. So that's why I often request the IT personnel to join the team when the client is structuring the compliance system. I will ask the panelists of the first session the same question that is raised, maybe starting from Inu.
Hi. My recent advice, it's actually not much different from yours. Essentially, it's also so I would ask my client, who normally is the legal counsel, to first have conversations with the product design, and this is from a compliance perspective, to first have conversation with the product design team, the sales team, especially if they're dealing with sales of data or utilization of data. And if and when possible, then to have a consolidated understanding before coming to us. But it is, I guess, not very different from yours. I think that's really the best way to go ahead, because I guess sometimes from a legal perspective, especially some of the in-house counsel who are not familiar with data, they may not understand how the data is actually really, what data is actually being collected, how it's actually used. They don't understand the data flow, right? And that's when the gap will be when they instruct us. So I think it's quite important for them to understand the product well, or the data flow well. Yeah, so that's what my recent advice actually. It's quite timely that you raised this.
So how about you, Jihong?
Yeah, thank you, Akira. And firstly, my legal team will use some lawyers with technical background, and they can end the product well, and it will enhance our capability to understand the products of the client. And secondly, before we give any compliance advice, we'll conduct an audit on the client's products and understand the IT perspective, and understand the management and technical measures they have taken, and understand the data flow. And so it is a comprehensive understanding regarding the products of the client. And then we'll give the gap analysis, give the advice. During the implementation of the compliance, we'll advise tools, PBD, privacy by design, and we not only give some remedy measures to client, but also during design and the process of the products, we will advise on how to give the compliant advice in advance before the product and before the sales. So it is very effective than the remedy after the incident.
Thanks, Jihon. Let's fly to the EU side. So shall we start from Poland?
Yes, I think that sometimes this gap is a little bit artificially created, because I believe that lawyers really start to understand IT people more, because to be an IT lawyer, you need to understand IT language and IT technology, because otherwise you cannot advise. And I think it also works the other side. So more and more IT people really understand the legal language behind the IT technology. So more and more what I see is that if the conversation is started between IT people and legal teams very early in the process, there is no gap. And this understanding is really great. And I really like working with IT people. because they really contribute to our knowledge and understanding how the law, how to really apply the law in this very complicated technological system. So I think that we should just work more together with IT people as legal teams.
Thank you, Agnieszka. I totally agree that we lawyers ourselves are not very much specialists of the IT systems because our background is law. But once we started advising on the data privacy issues, because of the communication with the IT staffs in our client's team, I believe we are getting more and more detailed knowledge on the IT system itself sometimes, because that understanding is sometimes fundamentally important. So, shall we turn to UK? Kim, please.
Yeah, I would simply echo a lot of what's just been said. The GDPR talks about appointing a data protection officer, and there's a lot of focus on the role of the data protection officer. But in practice, a lot of my clients, well, it's unfair in a way to put the whole burden on the data protection officer, who tends to be a compliance specialist. So a lot of my clients set up GDPR panels, which is essentially legal, compliance, and IT, and it helps everybody on the panel understand everybody else's area. So the IT people on the panel understand that GDPR compliance isn't just sort of cybersecurity. It goes way beyond that, and it helps the lawyer and the compliance people understand, how the technology operates in practice and how the requirements of the GDPR can sort of feed right the way through an organization.
Thank you very much, Kim. And to wrap up the Q&A session for session 1, I would like to ask each of the panelists in the session 1 key takeaway, echoing to Andrea's comments that the complexity and plan. So what is a key takeaway for Japanese companies as to your jurisdiction on one key takeaway when they are implementing a compliance structure or updating it as to your jurisdiction? And my comments to this point is that because of the complexity, in many of the cases, what I see is that the company, when they are operating in multiple jurisdictions, especially when they are MNCs, they prepare an umbrella data processing agreement or umbrella data transfer agreement, which could be used in multiple jurisdictions. Most of the essential points are mutual. However, because of the needs for localization, the appendix or the appendixes should be created for each jurisdictions to comply with their local or unique regulation. And what in most cases, my experience is that updating such appendixes in many of the jurisdictions periodically, like once there is an update in the regulation or once there is an judgment made by the court, which may impact the compliance structuring, they have to update that what is written in the appendix. And to gather the information timely and to update such appendix is what I see as a necessary steps to comply with the rapidly changing regulations globally. So now I believe I gave sufficient time for each of the panelists to think about one key takeaway. So can you try to summarize very short, starting from in Singapore?
Thank you, Akira. That was very essential. I thought I would have to do a key takeaway in 1 minute. I think adding to what you have mentioned, perhaps MNCs with various entities could look at getting accreditation if need be, if some of the entities are actually dealing with the data. That would ease quite a lot of issues. The second thing also is to take a step back and understand why the data needs to be transferred in and out of certain countries, looking at the advantages of the laws of certain countries and how strict certain countries are, and probably designing data flow that way as well, if there is the luxury of doing that. Because, for example, some clients of mine, their data scientists sit in one jurisdiction, but their target data subjects sit in another, and they would transit through Singapore, for example. So these are things that I would probably also advise clients to take a step back and look at. Yeah.
Thanks, In. Next to China, Jihong, please. Maybe
Jihong, you are muted.
Until now, at our discussion, I think that we can make a conclusion that Chinese legal regime regarding cybersecurity and data protection is quite complicated. For foreign companies doing business in China, it is critical to engage our qualified lawyers understanding the legal regime, understanding the enforcement focus by the government, and then the outside counsel can give a very qualified and efficient advice.
Thank you for mentioning the very important point, Jihong. So flying to Europe, so Agnieszka, Poland, please.
I think that the takeaway is that the system of data protection is becoming more and more unified across the world, and more countries are actually giving this adequate level of protection for personal data. So I think that this is one point. The second point is that there are still differences, and I think that these differences, they arise from different backgrounds and probably different systems that the countries come from. And of course, we still have to monitor those differences in order to make sure that the data is being processed and transferred in the legal manner. I think that the concepts like the European Union, where you have the unified system of data protection, is definitely the way forward. As someone mentioned, the data doesn't know the boundaries. So as more we unify the system, the easier it will become. Thank you.
Thank you, Agnieszka. I totally agree with you. Although Japan is an adequate jurisdiction with both of Poland and UK, the regulation is similar, more becoming uniform, but there is also a difference. So this makes still complexity. So the last panel, Kim from UK, please.
Yeah, it's fairly straightforward from me. If you're a business doing business in the UK through Europe, then you should be mapping your data flows now and checking that from the 1st of January, you've got any appropriate safeguards in place so that your data flows aren't disrupted on and from that date. It's as straightforward as that. It's the priority for me at the moment anyway.
Thank you very much. I believe because we are almost approaching the end, maybe I should give the mic to Joe for Q&A session for the session 2, data breach management.
Well, I'll do that, and we'll just do one go round. I did notice some questions about what's the cost of breaches, and one of the questions was about the difference between breach of credit card information and breach of social security numbers in the United States or other countries, and health. I can tell you that actually health information is more valuable than financial information. This comes from who actually buys and sells this information, not just on the dark web, but on the perfectly proper web, so that large databases can be gathered. There's no simple answer, and in many countries, consumers can't really prove in advance what is the cost of a breach, because it hasn't affected them yet. And so the cost tends to be free credit reporting per year, something like that in the United States, and you often see this. But we're dealing with data breaches today, but we haven't included ransomware. A recent estimate is that the total cost of data theft, misuse, is probably approaching $1 trillion per year. That's a recent estimate from a US government source. So this is very serious what we're talking about. So let me do the same thing I thought Akira did brilliantly and give each of our the panelists for my session one key takeaway. That's a good way to put it. Not 5 or 6 or 7. We've had a lot today, but just what is one more you'd add as we wind up today? Let me start with Kohei. What would be the one takeaway, one tip you would offer here in our final round?
Sure. My message is just privacy is not defensive, it's just offensive. It's just strategies for the enterprises, because as I mentioned through my presentation, this is the communication with the customers. So all the companies need to have it in mind. What kind of the communication is the requirements for your data using? So this is essential. So my key takeaway is just this message to all.
Well said. Achieve privacy by design if you can. Thank you. Eric, let me turn to you. In the United States, and you'll have to unmute yourself. Frost Brown Todd has over 100 Japanese-owned businesses that operate in the States that we work with, and it's a very important part of our practice. What would be one key takeaway you would leave today?
As simple as it is, making sure that there's some form of a policy in place. I would probably argue that the written information security program is pretty important, but an incident response plan, an information security policy is necessary for any business that I think is operating in the US, both the process and having the policy in place for employees. Thank you.
Ken, let me turn to you for both, you're a lawyer, but you're such a technology expert with us today. We appreciate you being with us. One key takeaway you would offer to the audience.
Well, this actually will be partially a response to a question that came up under Akira's Q&A with the group, and this is this balance between lawyers and the technology side of the world. Lawyers are very, very good at issue spotting, understanding the etiology and root cause of problems. And lawyers are very good at pushing back. And I would encourage counsel that when you're dealing with those on the technical side of the house, do not accept at face value best practices. And I'll give you a concrete example. Today, it is considered best practice to encrypt. Okay, fine. But encryption is not the problem. The problem is who has the encryption keys, who has access to those. So for example, if you are using a generalized web provider, and it could be any of the large names, copies of those encryption keys exist. Now, this raises an interesting privacy question. They have access to the key, the data flows are passing through them. Could they, in fact, decrypt the data and look at it? Yes. Technologists tend not to go that deeply because most of us are looking for, give me a tool that I can apply. And so lawyers, I would admonish you to challenge your colleagues on the technical side to not accept that just because guidance is you encrypt, that's not your threat surface. Your threat surface is the underlying infrastructure, and really probe to make sure that your IT staff and your security staff understands the goal here is protecting the data. It's not about a particular process or procedure.
Thank you, Ken. Kevin, let me turn to you. One key takeaway you would offer.
I'd say it's engagement and endorsement, Joe, because it's all well and good having these fantastic policies and procedures, but what we really need, if we want everybody to take it seriously, at every level in the organization, we need buy-in from the board level and senior management all the way through the organization, because then people will be engaged, people will issue spot, and people will react in a proper and timely way. So I would say people need to be engaged.
Thank you. And Grace, your thought.
Thanks, Joe. I think my takeaway after hearing everyone speak and even the Q&A is that while a data governance framework can clearly be a very daunting undertaking for an organization, given the complexities involved, the different laws, the different specialties, legal, compliance, technology. Having a tool in place to make it more manageable for a privacy officer to even begin is quite important. And I would recommend looking into things like, in Canada, we use privacy impact assessments. I believe there's something called data protection impact assessments under the GDPR. But basically, it's a step-by-step process that analyzes the data, the personal information implications of every new endeavor, a new processing of information. It really breaks it down. There's tons of information about PIAs, as we call them, online, but I would encourage organizations to look into them as a helpful tool to manage these kinds of undertakings.
Thank you. And my takeaway would be form your team before there's a problem. And the team has to involve technology and law, absolutely both. And that's one reason PrivacyRules is designed as an alliance, not just of lawyers, but of attorneys and cybersecurity technologists. And you have to have it in advance. It's not just for prevention of data breaches, it's for keeping the trust of your customers, for not keeping data you don't need to have, for really protecting particularly sensitive data against the enormous risk of if you let it get out of hand. And one last point, I don't think we're going to have an international court adjudicating everything in perfect harmony in this anytime soon. Quite the contrary, we see data localization laws occurring in India and Russia, China to some extent, and elsewhere. And this is an additional reason this has to be dealt with on a global basis. Those are our thoughts. Let me turn it back to Andrea.
Joe, thank you very much. Arigato to Akira. I definitely have nothing to add anymore. I mean, all takeaways are absolutely to the point. I believe that everyone in the audience will benefit a lot from them. So I just want to thank everyone here, our moderators, our co-host Iwata Godo and Akira Matsuda from Japan, each and every one of you, and our warm invitation. Follow www.privacyrules.com. Please follow us on our LinkedIn account, on our Twitter account, in order not only to receive the recording of these fantastic sessions, but also information related to all our future activities. They will be on a variety of areas. In 2021, we are launching our global services. We have the Asian Committee, we have the European Committee, and many other committees, starting from the Cybersecurity Partnership Program, which will be chaired by Ken. So thanks a lot to everyone. It was good to have you again today, and it will be very nice to see all of you again in 2021. And we take the chance actually to also wish happy seasonal holidays in this terrible year for the pandemic. Thank you very much again.